Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and my co-host today is Blair Matthews. Hello, Blair.
Hi, everyone.
Today's episode is How Should Killer Acquisitions Be Assessed? A discussion with Professor Nicolas Petit. We'll be considering the analysis of so-called killer acquisitions in merger control, including a 2025 article published in the section's Antitrust Law Journal titled Killer Acquisitions, Evidence from European Merger Cases. We have a link to that article in the episode details. Our guest today is Professor Nicolas Petit, a co-author of that 2025 ALJ article. Nicolas is Professor of Competition Law at the Department of Law of the European University Institute, or EUI, in Fiesole, Italy. His research in recent years has focused on EU and US competition law, competition and innovation, law and economics, and law in the context of technological change. Hello, Nicolas, and welcome to the show.
Hello, it's nice to be with you.
Well, thank you for joining. As an introduction, I think it's useful to establish some terminology. The phrase killer acquisition is, as listeners will know, principally used to refer to the acquisition of a nascent or emerging innovative competitor by a large established player to protect its market power. Or in other words, often to discontinue the target or shut it down as a potential future competitor. There are also reverse killer acquisitions where the buyer's competing product is discontinued, delayed, or reoriented following an acquisition of such a competitor. Those are classic horizontal situations, but killer acquisitions can also refer to an acquisition of a nascent player in a non-horizontal setting, of which the well-known Illumina Grail case raising vertical issues is probably a very good example. As we will see, this remains very much a live issue for both the European Commission and other competition regulators in the EU and elsewhere on the jurisdictional and the substantive sides. So, Nicolas, against that background, why do you think killer acquisition theories of harm in merger control are particularly relevant at the moment and something we should be discussing here?
Okay, that's a great question. So one finding that the literature tends to suggest since the publication of the initial paper on killer acquisitions is that this phenomenon, this problem, has been slightly exaggerated. And it doesn't travel to industries other than pharmaceuticals or biochemicals as easily as enforcement agencies have been believing following the publication of the paper. So there are enormous complexities and complications that make the theory not so much a theory, but more of an anecdotal problem that deserves to be addressed in the marginal case, but that doesn't deserve a change in legal standards or jurisdictional thresholds, as some have advocated for this past few years. So you would expect today, with the benefits of hindsight and research that has put to the test the findings of the original study that were about the pharmaceutical industry, that indicated a very narrow concern, 5 to 7% of these acquisitions would give rise to a killing. You would expect the agencies to respond to the evidence that's coming in, to say, well, maybe we should not get too hyped about this and maybe pose down these calls to change merger law. But what we are seeing is something slightly different. So there is a recomposition, I think, in the international landscape, merger landscape, where you can see a certain degree of specialization of various jurisdictions. So if you take the US, it's fairly clear today that the Trump administration wants to have this very, in the diplomatic way, I would say, transactional approach to merger, where every merger transaction can be traded against another goal, like a trade objective or a geopolitical objective or a security objective, or building factories in America, right? So you could think like the next merger transaction that comes to the DOJ or FTC will be an opportunity to discuss whether the merging parties are ready to build in the US some factories or what have you, and in exchange for that, get this deal going. In the UK, so you could call this transactional. You could call this, if you were less diplomatic, you could call this extortionary, right? And the theories help this, right? This theory that raised the bar for merging parties without many limiting principles create leverage for a very opportunistic agency or executive. In the UK, I think it's different. In the UK, we've seen the government completely change course, being the champion of merger enforcement these past few years, blocking transactions like Facebook Giphy and signaling hostility to others. And then the Starmer government said, no, now we have to be very pro-growth. We have to signal to markets that M&A is welcome. When there is efficiency, we should not be too hard with remedies and so on and so forth. And the CMA has completely flipped in terms of, I think, how it signals its attitude to mergers, right? So we've gone from a very, I think, anti-merger approach to a very pro-merger approach. And I think in the EU, as usual in the EU, we are a little bit in the middle and a little bit unclear on what we want to achieve. So, I think that's where we are. There's this consultation on merger efficiencies and dynamic effects of merger. It's broader than just efficiencies, but efficiencies are really key. And we don't know where the wind is going to blow.
That's a very interesting take, Nicolas. I mean, just before we move on, just to comment that the mission letter to the new competition commissioner expressly in the EU expressly calls out the need to address the risks of killer acquisitions from foreign companies. And also it's notable that previous commissioner, as recently as September 2024, said that killer acquisitions are among the most critical competition challenges that we face today. And it's a clear and explicit objective for the next commission. So interesting kind of comments there, I thought, against that background that you've just outlined.
The backdrop is also interesting in the US as well, where, we have the second Trump administration taking the reins, and both Gail Slater and Andrew Ferguson have been very vocal about the role of competition law in addressing threats to innovation, which makes these potential competition issues particularly relevant for our purposes. And I do think while the pursuit of killer acquisition theories was a real kind of hallmark of the Biden administration, what's interesting to remember is that the first challenge to a potential competition case in the US was actually under the first Trump administration, with CDK Automate. And so kind of looking at how the approach to these types of transactions has evolved over time is quite interesting. And it's very prescient that we're exploring it today. I was hoping, Nicolas, that you could lay out some of the methodology in your killer acquisition paper in the Antitrust Law Journal that Matt mentioned at the beginning of the show, which we've all read with interest.
Sure. Okay. That's great. So thanks for giving me the opportunity to talk about the paper. I want to say that this is not just my paper, as you rightly pointed out. This is a joint work with a young PhD student of the UI with a superstar, Selçuk Unegbas, and a more senior and seasoned empirical economist, Mark Ivaldi from Toulouse. So our study, I also want to say that the study is very modest in terms of what it claims, because we've basically focused on a very small sample of cases. So we are doing case studies, and we're studying give or take 12 cases that have been decided by the European Commission under the merger control procedure. And we look at these cases with the benefit of hindsight. So we look at data ex post to review whether in these cases the approval of the Commission, so all these cases where approval gave rise to what the theory predicts, which is, post-approval, once the merger is consummated, the acquiring company will kill the targets, right? And so we want to study cases in which the merger went through, and to study whether, at the time, the agencies were not really considering the killer acquisition scenario on its own terms, whether you can see the kill, right? So whether the products were killed, we say shelved, or whether the products were scaled. And to do that, we run, so what you do when you run these small sample case studies, to be serious, you have to put them to a form of intense testing exercise, right? So you try to compensate the small size of the sample with very intense analytical work on each case, right? And so we deploy 3 different tests on every of these cases. So the first one that we run is what we call the perception of the target test. So what we do is we try to identify who are and where the competitors of the target firm, and we try to see if in their official disclosure documents, like 10Ks, following the acquisition, the competitors of the target keep talking about the target or its products, right? Because if you see post-merger that the competitors identified by the Commission of the target keep talking about it years later, it means that this company has not disappeared. It's not been sort of shelved into the acquiring company, right? So we run. That's the first test. The second test that we run is whether the competitors of the merged entity post-merger have grown or have declined, right? And so we look at official statements again to shed light on whether the merger led to an increase or decrease in external competition. Because in the killer acquisition scenario, the killer acquisition scenario is only a concern if they are the kill, of course. But if the kill is not compensated by an increase in external competition, if there is external competition on the merged entity with or without a kill, then a merger agency should not be worried, right? Competition remains intense. And so we look at output data. The filter that we have is not great because we don't have really data that is segmented to the relevant markets that the agency looked at. It's very hard to get this data handy from public sources, but we think we have a good enough data set and set of indicators to establish that. The third thing that we look at, and I'll stop here, is whether post-merger some competitive events took place that would relativize or nuance or counterbalance any possibility of a kill. So by competitive events, you can think about the entry of a new firm that didn't exist at the time of the merger in the product space, or the launch of a new product by one of the existing firms at the time of the merger, or the transformation of the incumbents that would sort of completely scale and enter into new markets and create innovation that displaces everything, right? So that's what we do, and we think that if we focus on digital industries, which is the scope of the paper, so one thing I didn't say, I should have said that before, is the Killer Act initial paper was on pharmaceuticals. But then the statement that you referred to, Matthew, were mostly statements from officials about the state of affairs in digital industries, right? So Killer Act arises in the pharmaceutical context, and everyone gets completely overexcited with the digital industry, right? And so most of these repeated calls to use the theory concern digital industries. So in the paper, we looked at digital industries, and we don't find a problem that has the sort of magnitude and intensity that the theory would predict, right? So we think the paper nuances a little bit, and if it doesn't come to clear conclusions, we think we've tried to provide a good enough test to think about this in the future.
As you say, this would take cases, I think, all you considered or identified as susceptible to being considered killer acquisitions, although approved, as you say. Just a follow-up here. I mean, as you said, Nicolas, small sample. What are your concerns about, so leaving that aside, but what are your concerns about the bluntness or otherwise of these three tests? You referred to the post-merger rival perception test, the post-merger rival sales test, and the post-merger competitive events test, I think is what you called them. So just briefly, what are your kind of concerns about the bluntness or, real rigor of those, what you're able to identify from the 10Ks, etc.?
Well, so there are very well-known concerns with financial disclosures, right? So firms may overstate or understate their competition in these documents depending on the context or the environment in which they are found when they report, right? And also firms are just very different in terms of how much they disclose, right? So some firms have a tradition or culture of secrecy. They are going to be very generic. Others are going to be very explicit. So that is like a main, I think, methodological problem for at least the first and the third test. And for the second test, like I said, we don't have very granular data on that would from competitors that talk about the same market that as the competition agencies talk about. So this relevant market that antitrust agencies discuss only exists in the antitrust world. In the financial disclosures or financial markets, people do not think about the markets for perfect or quasi-perfect substitutes.
So just turning back to the findings of your article that you mentioned earlier, Nicolas, we read with interest, kind of despite looking at a smaller sample size of some of these transactions, you were able to essentially see that none of the reviewed transactions actually resulted in the disappearance of the target's products or a weakening of competing firms or any type of post-merger lowering or absence of entry or innovation. I was just curious if you could build on that a little bit and kind of explain how you got to that point in the paper.
Yeah. So I guess, it's the paper. I think the paper has the strength of its weaknesses, as we would say in French, which is that I think we have a pretty clean test. So conceptually, the three-pronged test is very clean and logical, right? So these are the questions you would like to answer if you wanted to have a definitive answer, a definitive determination of whether there was a kill or whether there was no kill, and whether the kill was competitive or anti-competitive, right? Then the operationalization of that test is where things get a little more dirty. But again, I was reading court judgments earlier, and judges do not work with the level of empirical sophistication and elegance that is often required from econometric papers. So if you read a judgment like, let's say, a killer acquisition one, Meta within, the judges end up, talking about the outcomes and the predictions on balance, right? And I think in our paper, we end up having this form of unbalanced prediction at the end, right? On balance, we feel that the three-pronged test gives us like the sign that this is not so prevalent. And so it's more lawyer paper to that extent. I don't know if I answered your question, but...
So I think you conclude that there seems to be no under-enforcement, and also you use this to support that there doesn't need to be additional control of below-threshold transactions, which of course is a huge issue or discussion point in the EU and other places.
Yeah, so there I have something I want to say about this, because that's not in the paper, but I think that's probably a useful addition that will, maybe make people more confident when they read the conclusion. So all these transactions were transactions that crossed the threshold for review, which is pretty high in the EU, right? So this involves, you could say, large firms or large transactions. And of course, some people would say, well, all right, you've seen these effects above the threshold, but below the threshold, things might be very different when they involve very small companies, right? And so there is this possible heterogeneity here that would point out to no harm to competition in the big cases, but maybe harm to competition in the small cases, right? So this is where I want to add a piece of evidence that was not in when I had the paper. I wrote the paper with my colleagues. So if you focus on digital industries only, right, we have now statistical evidence that shows that relative to other industries, ICT has created more new firms in the past 40 years than any other sector of the economy, right? And so I even have I have numbers in another paper, but you can think about, since like 1978, which is when I was born 46 years ago, the US economy has added, more than 30,000 new firms that still exist in the ICT industries. If that data is right, then it probably means that the concern below the threshold in ICT sectors is irrelevant, because the rate of entry in these industries lends credence to a statistical argument that whatever you do in digital, if you take out one firm, the rate of entry is so strong that there will be a replacement orders of magnitude larger by new firms that enter and expand, right? And so I think that's something that we need to be very aware of, because that's also, to the paper here, leads to this conjecture, leads to having some confidence in the conjecture we're making that what you see above the threshold replicates below the threshold.
I guess that makes sense at a macro level. Of course, merger control looks at individual transactions, doesn't it? And you don't know the counterfactual to your high level take. So let's look at some more recent cases. Nicolas, you actually referred to this one in your paper, or the joint paper at the beginning. I'm interested in your thoughts on what happened here. This was the Meta within transaction that closed in February 2023 and was unsuccessfully challenged by the US FTC.
Yep. Okay. So that's an interesting case too. There would be so many things to say. I would assume this is a case that was brought by the FTC under the Linecan mandates, and lots of people read this case as a good instantiation for the neo-Brandeisian / killer acquisition thing. So Meta would basically buy this firm within. So Meta with its VR headset business and VR platform business would buy this Complementer, which is a VR fitness app, to prevent a risk of competitive disruption on its own activities, right? And for that theory to hold, it would either require that Wisin would enter the VR headset market. I don't think this was an assumption that the FTC was making, but rather that Meta would be interested in entering the VR fitness market, right? And there's been this assumption that has, I think, widely and maybe exceedingly pervaded the academic and maybe the policy discussion, that anything that a complementer can do, a gatekeeper can achieve through vertical integration. So there's nothing that these big platforms cannot do, right? There's no piece of software or application that they cannot build, right? I think the case was useful because the judge in the case reviewed the evidence very carefully and confirmed a bunch of things, like on market definition, which is often very challenging in digital markets. Confirmed also the market concentration statements, which I think were quite interesting and harassing to some extent. The HHI was above 6,000. I mean, I don't know how this was calculated, but I promised to myself that I would look again into this. But then the judge confirmed a bunch of things that the FTC tried to argue. But at the end of the line, the court considered that Meta didn't have the capability to, in the short term, so the time horizon relevant to merger review, to develop a dedicated fitness app like Supernatural from within. It didn't have the right trainers, you need trainers to create these workouts, and so you need a lot of expertise and capabilities. And I think this is a good example of a case that doesn't take the conjecture of killer acquisition for granted, right? It puts a very strict test and admits a bunch of things, but challenges others.
As you say, despite unlimited funds, effectively, the judge concluded that Meta did not have the available feasible means to enter the relevant market other than by acquisition. So a very interesting conclusion there.
That's right. So I think, and maybe the take of this is that the courts, I mean, I always place a lot of trust in the court. I know I'm not a practicing lawyer, so maybe I'm overconfident in this, but they played a good role here, especially in the US, where the standards of evidence and review are extremely high. I think you can see that in this case. It's a good example of a case in which the judges do not get too dragged into this, policy convo that is in a way self augmenting, right? So everyone gets excited. The concept, the killer acquisition. The good thing about this, I want to say this about the killer acquisition thing. This is a story that's too good to be untrue. Everyone likes this. It's like it talks about blood, and it's really captivating to think this way, right? So everyone wants to believe this, and so it's very hard to push back. There's this Nobel Prize economist Robert Shiller. He has a book on economic narratives. It's about these like small theories which don't have a lot of evidence to back them, and then they get viral. Everyone wants to believe them. Economic narrative, and I think the killer acquisition theory has a little bit of that. It's become an economic narrative. It's a bit like the discussion on the consumer welfare standard in standard antitrust, right? It's a bit the same stuff. Like the consumer welfare standard has killed antitrust enforcement these past 50 years. Again, that's another economic narrative that doesn't touch the ground. It's based on speculations and imagination.
It's also been killer acquisition, certainly been the source of a lot of panels at conferences, right? I sense some criticism there but beyond our discussion today, really, of the European Commission administrative model, as opposed to the US, court model. But just a topic for another day there.
So that was really interesting context from you, Nicolas, on the Meta Within decision. As I'm sure you know, there was also the challenge to the Steris case, which occurred and which the government also lost. I am curious what your take is on the recipe for a successful challenge under a potential competition theory. What ingredients do you think agencies should be looking for in bringing one of these challenges successfully?
Right. Okay, that's a very good question. All right, I would say, for a start, that these cases would work if you have strong evidence, and mostly I would say internal documents from people with really high-level managerial authority, statements that allow the agencies to build a very strong counterfactual to the merger, right? So like, if you think about MetaWithin, if there was, a good paper trail from within Facebook where Zuckerberg would say, well, I'll bet the company on a fitness app, like you did, like you said, I'm going to bet the company on headsets, right? Well, then, that type of commitment from the high-level management of the firm, that would identify a competitive threat, that would, then show financial and decisional commitment to do whatever it takes to do this. I think that would be key. And you can see that in another case, which the DOJ, I think, litigated, which is or started to challenge the Visa Plate case, where this complaint was full of evidence about the sort of very careful understanding that Visa had of the threat represented by Plate to its business and what it wanted to do with it. So I think internal documents could be key, not from anyone, of course, not just hot dogs, but something like pretty serious. I would say that the institutional environment plays a key role. So to that extent, having something like other agencies in the world taking the same line would bolster confidence in the agency that they're doing the right thing. And so, in cases like Adobe Figma, for instance, or cases like Microsoft, Activision, Blizzard, you could see that most agencies were advancing the case at the same speed and with the same concerns. Of course, they didn't end up deciding the same thing, but you could see the pressure building up, and that helps a lot in getting enough confidence and legitimacy for trying to do something about it. And then maybe one last thing, I think I keep thinking that horizontal cases are easier, if that makes any sense in digital. So a clean overlap will, if a gatekeeper tries to buy something that has such clean, nice horizontal overlap, that would be a very easy case. So if you think about, I don't know, a company like, take any gatekeeper that has strong presence in AI internally, trying to buy another AI firm, the horizontal overlap would be just too blatant.
So next question for you. Looking ahead, how do you see the framework for evaluating these transactions evolving? And also, what role do you think that internal modeling from companies where they put projections around, potential entry into certain product areas, what role do you think that will play in agency decision making?
Wow, yeah, that's another very tricky and good question. So, like, to the extent of to the extent of this question of internal documents becomes important. So I think this is key, right? So if you can show it's not so you have the type of commitment that the management would need to make to show incentives to do something. And then you'd need this backing from technical documents internally to suggest that there is also a good understanding of the situation and the capability to do it, because the situation has been diagnosed with, the problem has been diagnosed with enough precision that the company with its resources can address it through an acquisition. So I would say that in the totality of the evidence that you would need to bring, these two sets of internal documents, the internal modeling from the company and the sort of managerial strong signals of committing to do something for real, that would be key. One thing, I don't know, Blair, Matthew, you're the practitioners here, so you know this far better than I do. But one thing that often struck me in these digital cases is that, even though we are talking about very high-tech industries, the sort of mode of evaluation from an antitrust standpoint relies a lot on, what economists would call structural analysis or qualitative analysis, right? So if you take MetaWithin, for instance, it's, go back to the brown shoe indicators. And you don't do much hypothetical monopoly stuff. You don't do much, elasticity, price elasticity, cross-price elasticity, critical loss analysis, and so on and so forth. You don't have a lot of prices to which you can latch onto to apply all this econometrical stuff. So it seems to me that is also something that plays a role in at the same time maybe making the entry cost into a case like this for the agency lower, but at the same time making the challenging costs higher because everything becomes up for grabs and up for discussion, right? I know what
I think that's right, and that came out in the meta within judgment, I think, where they were looking, at objective evidence, which seems to have been kind of testimony, and also, quote, subjective evidence, which was looked at as well, as opposed to kind of econometric type analysis. And ultimately, picking up on your point, it seems they gave not a huge amount of weight to what the executives actually said in court, but relied a lot on contemporaneous statements in the documents. So I think it was picking up on your point beautifully there. Great discussion, Nicolas. Thank you very much. We like to finish our episodes with a little personal questions. Firstly, could you please tell us something interesting about yourself that people wouldn't know, that is outside of your professional life?
Okay. Okay. Yeah, I know. I think I know. So I've been often asked, why are you interested in this thing, competition? And I often reply that the reason for this is that I have a twin brother. And as a twin, if you grow up as a twin, you realize that most of the things you do every day is trying to think about how to strike the balance between competition and cooperation, right? So you're competing for your parents' attention all the time, and you're competing in class for the best grades. But at the same time, you need to cooperate because, I don't know, you get a problem in the street, and there's four guys that are trying to take your scooter, and so you have all these things, right? Cooperation and competition. So I like to think that having a twin created sort of intellectual predisposition to the philosophical intellectual question of where is the right balance between competition and cooperation. And this is exactly what private practitioners in antitrust, economists, agency officials try to do all the time. Where is the right balance between cooperation and competition? Should we let these companies merge and cooperate, or should we require them to compete, right?
That's an amazing link between twins and competition law, for sure. And also, in fact, interestingly enough, you're the second twin we've had on this podcast who is active in the competition or economics field. So that's pretty interesting. He didn't make that comment, but maybe next time he's on, we can ask him about it.
We can start a club.
Right. We'll get you linked together. It can be an exclusive club. So now we like to have our special section called The Curious Hat.
And now it's time for The Curious Hat.
Great, Nicolas. So a pretty softball one for you today. What was the last book that you read? And tell us a little bit about it.
Okay. The last book that I read is Memories of Hadrian from Marguerite Yourcenar. She's a French writer. I read the book in French. It's an amazingly beautiful book. The style is unmatchable in French. I know it's been translated in English. I know if the translation works equally well. But I have to say that I'm 46 today. I don't think I've read something as beautiful style-wise in the past 30 years. It is stunningly beautiful language. It talks about it's about the Roman Emperor Hadrian. At the end of his life, he writes a letter to his nephew to talk about the things he's gone through his life, and it's about art, power. It's about wisdom. There's a lot of philosophy, nature versus nurture. It's about Greece and how Greece was influential, Greek culture on him. It's about wars and peace. It's a beautiful book. I strongly advise it. I'm sad I read it so late, actually.
You give a really good sell of it, so I'm gonna have to check it out. We really appreciate you joining us, Nicolas. This has been very interesting, and I'm sure our audience will find it illuminating.
Thank you very much, Professor Nicolas Petit, for joining us today. And thank you, listeners, for listening to this episode.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.